FCLE Executive Actions Explained. Question 1. How long is the standard constitutional term of office for an elected member of the United States Senate? Option A, 2 years. Option B, 4 years. Option C, 6 years. Option D, 8 years. The correct answer is option C, 6 years. U.S. senators serve 6-year terms. Representatives serve 2 years, presidents serve 4, and 8 years is not a Senate term. Longer Senate terms were designed to create stability and independence. Question 2. In Federalist No. 78, Alexander Hamilton described the judicial branch as the least dangerous branch. For what primary reason? Option A. It possesses neither the power of the sword nor the purse, it has only judgment. Option B. It is entirely subordinate to the dictates of state-level governors. Option C. Its members can be fired at any time by a simple majority vote of Congress. Option D. It lacks the authority to review any laws related to national defense spending. The correct answer is option A. It possesses neither the power of the sword nor the purse, it has only judgment. Federalist No. 78 described the judiciary as least dangerous because courts have judgment but not the sword of enforcement or the purse of spending. It was not because judges answered to governors or could be fired by Congress. Hamilton used this argument to defend judicial independence. Question 3. Which historic executive order issued by President Harry Truman in 1948 desegregated the United States Armed Forces? Option A. Executive Order 8802. Option B. Executive Order 9066. Option C. Executive Order 9981. Option D. Executive Order 10730. The correct answer is option C. Executive Order 9981. Executive Order 9981, issued by President Harry Truman, desegregated the U.S. Armed Forces. It is not a statute or court case. Truman plus military desegregation points to EO 9981. Question 4. What executive official serves as the head of the Department of Justice and the chief law enforcement officer of the federal government? Option A. The Secretary of State. Option B. The Chief Justice of the United States. Option C. The Attorney General. Option D. The Director of the Federal Bureau of Investigation. The correct answer is option C. The Attorney General. The Attorney General heads the Department of Justice and is the chief law enforcement officer of the federal government. The Secretary of State handles diplomacy, the Chief Justice leads the Supreme Court, and the FBI Director heads a bureau within justice. Federal legal enforcement points to the Attorney General. Question 5. What constitutional requirement must be met for a law enforcement officer to obtain a valid search warrant? Option A. Universal public approval. Option B. A verbal directive from a police chief. Option C. Probable cause supported by an oath or affirmation. Option D. A simple majority vote from a local city council. The correct answer is option C. Probable cause supported by an oath or affirmation. A valid search warrant requires probable cause supported by oath or affirmation and must describe the place and items with particularity. Public approval, a police chief's verbal order, or a city council vote cannot substitute for Fourth Amendment standards. Probable cause is the key threshold. Question 6. What type of power is explicitly written down in the text of the Constitution for a specific branch of government? Option A. Implied power. Option B. Expressed, or enumerated, power. Option C. Inherent power. Option D. Reserved power. The correct answer is option B. Expressed, or enumerated, power. Expressed or enumerated powers are powers written directly into the Constitution. Implied powers are derived from written powers, inherent powers come from national sovereignty, and reserved powers belong to states or the people. The phrase explicitly written down points to enumerated power. Question 7. Which core democratic practice requires public officials to remain transparent and answerable to the electorate for their official actions and decisions? Option A. Gerrymandering. Option B. Executive privilege. Option C. Political accountability. Option D. Judicial lifetime tenure. The correct answer is option C. Political accountability. Political accountability means public officials must answer to voters and the public for their decisions. Gerrymandering manipulates districts, executive privilege shields some communications, and lifetime tenure insulates judges from elections. Accountability depends on transparency, elections, and public scrutiny. Question 8. Which executive department is tasked with conducting international relations, managing embassies, and advancing American foreign policy interests? Option A. Department of Homeland Security. Option B. Department of Defense. Option C. Department of State. Option D. Department of Commerce. The correct answer is option C. Department of State. The Department of State conducts diplomacy, manages embassies, and advances foreign policy. Defense handles the military, homeland security, domestic security, and commerce, business and trade programs. Embassies and diplomacy point to state. Question 9. Which ideological viewpoint emphasizes minimal government intervention in both economic affairs and the personal lives of citizens? Option A, socialism. Option B, libertarianism. Option C, authoritarianism. Option D, communism. The correct answer is option B, libertarianism. Libertarianism emphasizes individual freedom and limited government involvement in both markets and private life. Socialism and communism involve greater collective or state control over economics, while authoritarianism limits personal and political freedom. The memory cue is maximum liberty with minimal state intervention. Question 10. Which House of Congress has the sole constitutional authority to hold a trial and vote on whether to convict and remove a president who has been impeached? Option A, the House of Representatives. Option B, the Senate. Option C, the Supreme Court. Option D, the Court of Appeals for the D.C. Circuit. The correct answer is option B, the Senate. The Senate holds the impeachment trial and votes on conviction and removal after the House impeaches. The House brings charges, while the Supreme Court does not remove the president by impeachment vote. For presidential trials, the Chief Justice presides, but the Senate decides. Question 11. In Federalist No. 10, James Madison argued that the mischiefs of factions could be best controlled by what type of governance structure? Option A, a small, direct democracy with highly localized assemblies. Option B, a large representative republic that prevents any single faction from easily dominating. Option C, a strong, absolute military dictatorship that suppresses political debate. Option D, a confederal system that gives individual states absolute veto power over all national laws. The correct answer is option B, a large representative republic that prevents any single faction from easily dominating. Federalist No. 10 argues that a large republic controls factions by multiplying interests and making domination by one faction harder. A small direct democracy would be more vulnerable to majority passion, and dictatorship would destroy liberty. Madison's answer to faction was representation across an extended republic. Question 12. What percentage of individual states must ratify a proposed constitutional amendment for it to become part of the U.S. Constitution? Option A, 50%. Option B, 66%, 2/3. Option C, 75%, 3/4. Option D, 100%, unanimous. The correct answer is option C, 75%, 3/4. 3/4 of the states, or 75%, must ratify a proposed amendment for it to become part of the Constitution. 2/3 is the usual congressional proposal threshold, and unanimity is not required. This high bar protects constitutional stability. Question 13. Which system of government concentrates all administrative and governing authority within a single centralized national entity, leaving regional governments with little to no independent power? Option A, federal system. Option B, unitary system. Option C, confederal system. Option D, anarchist commune. The correct answer is option B, unitary system. A unitary system places final governing authority in one central national government. Federalism shares power with states, confederation makes the center weak, and anarchism rejects formal governing authority. The key clue is regional governments having little independent power. Question 14. Which amendment ensures that any expansion of federal authority must be tied to an explicit or implied power, protecting local state control? Option A, Second Amendment. Option B, Fifth Amendment. Option C, 10th Amendment. Option D, 14th Amendment. The correct answer is option C, 10th Amendment. The 10th Amendment reinforces that federal authority must come from an expressed or implied constitutional power, leaving remaining powers to states or the people. The Second and Fifth Amendments protect specific rights, while the 14th limits states through citizenship, due process, and equal protection. Local control and reserved powers point to the 10th. Question 15. Which Enlightenment philosopher's ideas on social stability and the necessity of a social contract were modified by John Locke to include the right of revolution? Option A, Voltaire. Option B, Thomas Hobbes. Option C, Mary Wollstonecraft. Option D, Cesare Beccaria. The correct answer is option B, Thomas Hobbes. Thomas Hobbes argued that people form government to escape disorder, and Locke later adapted social contract theory to include natural rights and revolution against tyranny. Voltaire, Wollstonecraft, and Beccaria are important Enlightenment figures but not the direct social contract contrast in this question. Hobbes is the starting point for the strong government version of the theory. Question 16. What is the ultimate source of authority for all legal and political actions taken by the United States federal government? Option A. The Declaration of Independence. Option B. The United States Constitution. Option C. The Magna Carta. Option D. The current president's platform. The correct answer is option B. The United States Constitution. The U.S. Constitution is the supreme legal source for federal power and limits. The Declaration explains founding principles, the Magna Carta influenced constitutionalism, and a president's platform has no independent legal supremacy. Federal officials must trace their authority to the Constitution. Question 17. What was the core argument made by the Anti-Federalists against the ratification of the United States Constitution? Option A. The proposed Constitution did not give the national military enough domestic policing power. Option B. The strong central government would threaten individual liberties and state sovereignty without a clear Bill of Rights. Option C. The legislative branch was too weak to pass effective national infrastructure bills. Option D. The judicial branch was selected by the public rather than through executive appointment. The correct answer is option B. The strong central government would threaten individual liberties and state sovereignty without a clear Bill of Rights. Anti-Federalists feared the proposed Constitution gave too much power to the national government and lacked explicit protections for individual rights. They were not mainly asking for stronger military power or weaker legislative authority. Their pressure produced the Bill of Rights. Question 18. Which landmark legislation passed in 1993 required local law enforcement to conduct background checks on individuals purchasing handguns? Option A. The Gun-Free School Zones Act. Option B. The Brady Handgun Violence Prevention Act. Option C. The National Firearms Act. Option D. The Violent Crime Control Act. The correct answer is option B. The Brady Handgun Violence Prevention Act. The Brady Handgun Violence Prevention Act required background checks for handgun purchases through local law enforcement procedures and later federal systems. It is not a school safety, labor, or environmental law. Handgun background checks point to Brady. Question 19. What major environmental law passed in 1980 created a federal superfund to clean up uncontrolled hazardous waste sites across the country? Option A. The Resource Conservation and Recovery Act. Option B. The Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA. Option C. The Toxic Substances Control Act. Option D. The Solid Waste Disposal Act. The correct answer is option B. The Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA. CERCLA, commonly called Superfund, created a federal program to clean up hazardous waste sites and assign cleanup liability. NEPA reviews federal actions, while the Clean Air and Clean Water Acts regulate pollution media. Hazardous waste cleanup points to Superfund. Question 20. What landmark environmental legislation passed in 1972 regulated the discharge of pollutants into the nation's surface waters and funded sewage treatment plants? Option A. The Safe Drinking Water Act. Option B. The Clean Water Act. Option C. The Toxic Substances Control Act. Option D. The Resource Conservation Act. The correct answer is option B. The Clean Water Act. The Clean Water Act regulates discharges of pollutants into navigable waters and supports sewage treatment improvements. The Clean Air Act addresses air pollution, and CERCLA deals with hazardous waste cleanup. Surface water pollution points to the Clean Water Act. Question 21. What was the core perspective of the Anti-Federalist paper known as Brutus No. 1? Option A. A large standing army is necessary to protect a republic from foreign invasions. Option B. A free republic cannot exist in a large territory because representatives will become detached from the people and abuse power. Option C. The judicial branch should have absolute authority to rewrite state tax codes. Option D. The executive branch must be led by a council of 3 co-equal presidents. The correct answer is option B. A free republic cannot exist in a large territory because representatives will become detached from the people and abuse power. Brutus No. 1 argued that a large republic would make representatives distant from the people and prone to abuse federal power. It is an anti-federalist warning against consolidated national authority. This contrasts with Madison's Federalist No. 10 defense of an extended republic. Question 22. The 24th Amendment protected the voting rights of low-income citizens by outlawing what practice in federal elections? Option A. Literacy tests. Option B. Grandfather clauses. Option C. Poll taxes. Option D. Property ownership requirements. The correct answer is option C. Poll taxes. The 24th Amendment banned poll taxes in federal elections. Literacy tests and grandfather clauses were other discriminatory devices, and property requirements are a separate historical voting barrier. The amendment targeted the practice of charging citizens to vote. Question 23. Which type of opinion is written by Supreme Court justices who agree with the majority's ultimate decision but wish to emphasize a different legal rationale? Option A, majority opinion. Option B, dissenting opinion. Option C, concurring opinion. Option D, per curiam opinion. The correct answer is option C, concurring opinion. A concurring opinion agrees with the court's judgment but uses different or additional reasoning. A dissent disagrees with the outcome, while a majority opinion controls the ruling. Concurrence means same result, different rationale. Question 24. Which amendment guarantees a criminal defendant the right to a speedy and public trial by an impartial jury, as well as the assistance of legal counsel? Option A, Fifth Amendment. Option B, Sixth Amendment. Option C, Seventh Amendment. Option D, Eighth Amendment. The correct answer is option B, Sixth Amendment. The Sixth Amendment guarantees speedy and public trial, impartial jury, confrontation, and assistance of counsel in criminal prosecutions. The Fifth focuses on grand juries, self-incrimination, and due process, while the Seventh concerns civil juries and the Eighth punishments. Criminal trial procedure is the Sixth Amendment's core area. Question 25. What historical Roman Republic concept heavily influenced the American founders' emphasis on civic virtue and the public good? Option A, direct participation in tribal assemblies. Option B, republicanism and citizen representation. Option C, the absolute judicial authority of the emperor. Option D, the use of military tribunals for all civil suits. The correct answer is option B, republicanism and citizen representation. Republicanism in the Roman tradition emphasized elected representation, civic virtue, and service to the public good. Tribal assemblies, emperors, and military tribunals do not capture the founders' model of representative self-government. Roman republican ideas helped shape the American preference for a republic over monarchy. Question 26. Which constitutional amendment formally abolished the institution of slavery throughout the United States? Option A, 12th Amendment. Option B, 13th Amendment. Option C, 14th Amendment. Option D, 15th Amendment. The correct answer is option B, 13th Amendment. The 13th Amendment abolished slavery and involuntary servitude except as punishment for crime. The 14th addressed citizenship and equal protection, and the 15th addressed voting rights. Abolition is the 13th Amendment clue. Question 27. In Lemon v. Kurtzman, 1971, the Supreme Court established a three-pronged test to determine if a government action violates which constitutional provision? Option A, the Free Exercise Clause. Option B, the Establishment Clause. Option C, the Equal Protection Clause. Option D, the Privileges and Immunities Clause. The correct answer is option B, the Establishment Clause. Lemon v. Kurtzman created a test for Establishment Clause challenges involving government action and religion. Free exercise protects religious practice, while equal protection and privileges and immunities concern different constitutional rights. The Lemon test is linked to establishment of religion. Question 28. What is the purpose of the federal civil service system established by the Pendleton Act of 1883? Option A, to ensure all federal workers are hired based on professional merit rather than political patronage. Option B, to require all federal workers to enlist in the military reserves. Option C, to automate the drafting of environmental regulations using economic models. Option D, to allow the president to fire all federal workers upon taking office. The correct answer is option A, to ensure all federal workers are hired based on professional merit rather than political patronage. The Pendleton Act created a merit-based civil service to reduce patronage and the spoils system. It did not require military reserve service or allow presidents to replace all workers at will. Professional merit hiring is the key reform. Question 29. What is the purpose of the President's annual State of the Union address as required by the Constitution? Option A, to announce the direct suspension of federal income taxes for the year. Option B, to provide information to Congress on the condition of the nation and recommend necessary legislation. Option C, to officially swear in new members of the United States Supreme Court. Option D, to dissolve Congress and call for immediate special elections. The correct answer is option B, to provide information to Congress on the condition of the nation and recommend necessary legislation. The State of the Union informs Congress about national conditions and recommends legislative priorities. It is not a tax suspension, judicial swearing-in ceremony, or power to dissolve Congress. The address links executive leadership with congressional lawmaking. Question 30. Which committee in the House of Representatives writes the primary legislation regarding national tax codes and tariffs? Option A, the Appropriations Committee. Option B, the Ways and Means Committee. Option C, the Budget Committee. Option D, the Rules Committee. The correct answer is option B, the Ways and Means Committee. The House Ways and Means Committee writes major tax and tariff legislation. Appropriations allocates spending, budget sets budget framework, and rules controls floor debate. Taxes in the House point to Ways and Means. Question 31. In Hazelwood School District v. Kohlmeyer, 1988, the Supreme Court ruled that public school administrators can censor student-run school newspapers under what condition? Option A. Only if the newspaper articles contain explicit state-level criminal secrets. Option B. If the censorship is reasonably related to legitimate pedagogical concerns. Option C. Only if the students are compensated with academic course credit. Option D. If the school board votes unanimously to approve the censorship action. The correct answer is option B. If the censorship is reasonably related to legitimate pedagogical concerns. Hazelwood allows public school officials to regulate school-sponsored student newspapers when the action is reasonably related to legitimate educational concerns. Tinker protects independent student expression more strongly, but Hazelwood deals with school-sponsored speech. The clue is a student-run school newspaper under school supervision. Question 32. What type of jurisdiction allows a court to hear a case for the first time, establishing the initial factual record and legal arguments? Option A. Appellate jurisdiction. Option B. Original jurisdiction. Option C. Concurrent jurisdiction. Option D. Maritime jurisdiction. The correct answer is option B. Original jurisdiction. Original jurisdiction means a court hears a case first and develops the initial record. Appellate jurisdiction reviews decisions already made, and concurrent jurisdiction means more than one court system may hear a case. First hearing equals original jurisdiction. Question 33. Which piece of landmark legislation created the federal framework for safe working conditions, establishing a national enforcement agency for workplace health? Option A. The Fair Labor Standards Act of 1938. Option B. The Occupational Safety and Health Act, OSHA, of 1970. Option C. The National Labor Relations Act of 1935. Option D. The Social Security Act of 1935. The correct answer is option B. The Occupational Safety and Health Act, OSHA, of 1970. OSHA created the federal framework for workplace safety and health standards. Civil rights, environmental, or education laws do not establish the main workplace safety agency. Safe working conditions point to the Occupational Safety and Health Act. Question 34. What does the rule of law require regarding the transparency of legal statutes? Option A. Laws must be kept completely secret from the public to prevent criminal evasion. Option B. Laws must be clearly written, publicly accessible, and known in advance. Option C. Laws must be delivered orally by the executive leader on a weekly basis. Option D. Laws can only be modified by a secret committee of federal judges. The correct answer is option B. Laws must be clearly written, publicly accessible, and known in advance. Rule of law requires laws to be written clearly, made public, and known before they are enforced. Secret law, oral weekly commands, and hidden judicial committees are inconsistent with fair legal notice. Publicity is what allows citizens to understand and obey the law. Question 35. Which concept describes the idea that the law must be clear, publicized, stable, and just, applying equally to both the government and citizens? Option A. Judicial activism. Option B. Executive fiat. Option C. The rule of law. Option D. The mandate of heaven. The correct answer is option C. The rule of law. Rule of law means law must be public, clear, stable, and applied to both citizens and government. Judicial activism, executive fiat, and mandate of heaven do not require equal legal accountability. The concept rejects secret, arbitrary, or personal rule. Question 36. Which core democratic value is directly supported by the existence of a free, independent, and uncensored press? Option A. Administrative secrecy. Option B. Government transparency and an informed electorate. Option C. Unanimous political consensus. Option D. Single-party political stability. The correct answer is option B. Government transparency and an informed electorate. A free press supports transparency and an informed electorate by investigating officials and sharing information with the public. Secrecy, unanimous consensus, and single-party stability are not democratic goals served by press freedom. The First Amendment protects the press because voters need information to govern themselves. Question 37. Which landmark case placed a clear limit on the scope of presidential executive privilege, ordering the release of audio tapes during a criminal investigation? Option A. United States v. Nixon, 1974. Option B. Clinton v. Jones, 1997. Option C. Bush v. Gore, 2000. Option D. Marbury v. Madison, 1803. The correct answer is option A. United States v. Nixon, 1974. United States v. Nixon limited executive privilege and required the president to comply with a criminal subpoena for Watergate tapes. Clinton v. Jones involved civil litigation, and Bush v. Gore involved election recounts. Executive privilege versus criminal evidence points to Nixon. Question 38. Which clause in Article I gives Congress the authority to regulate commercial business activities that cross over state lines? Option A. The Taxing and Spending Clause. Option B. The Commerce Clause. Option C. The Origination Clause. Option D. The General Welfare Clause. The correct answer is option B. The Commerce Clause. The Commerce Clause gives Congress power to regulate commerce among the states. Taxing and spending concerns revenue and expenditures, while origination and general welfare are different congressional concepts. Interstate business activity is the Commerce Clause signal. Question 39. What did the Supreme Court rule in Wisconsin v. Yoder, 1972, regarding compulsory school attendance laws? Option A. States can force all children to attend public high schools regardless of religious objections. Option B. The Free Exercise Clause prevents states from forcing Amish children to attend school beyond the 8th grade. Option C. Public school curricula must include mandatory religious education options. Option D. Homeschooling programs must be funded entirely by local tax assessments. The correct answer is option B. The Free Exercise Clause prevents states from forcing Amish children to attend school beyond the 8th grade. Wisconsin v. Yoder protected Amish families from compulsory school attendance beyond the 8th grade under the Free Exercise Clause. The case balanced religious liberty against state education requirements. Amish schooling and compulsory attendance point to Yoder. Question 40. What is the constitutional purpose of separating the power to declare war from the power to command the military as commander-in-chief? Option A. To prevent the legislative branch from influencing foreign relations. Option B. To divide defense powers between the president and Congress, preventing military dictatorship. Option C. To allow individual states to veto international military engagements. Option D. To give the judicial branch supreme authority over military strategies. The correct answer is option B. To divide defense powers between the president and Congress, preventing military dictatorship. Dividing war powers prevents either Congress or the president from controlling military policy alone. Congress declares war and funds the military, while the president commands forces as commander-in-chief. The arrangement checks military dictatorship and preserves civilian constitutional control. Question 41. Which document was written to justify the separation of the American colonies from Great Britain by listing specific grievances against King George III? Option A. The Federalist No. 10. Option B. The Articles of Confederation. Option C. The Declaration of Independence. Option D. The Bill of Rights. The correct answer is option C. The Declaration of Independence. The Declaration of Independence justified separation from Britain by listing grievances against King George III. The Articles organized the first U.S. government. Federalist No. 10 defended the Constitution, and the Bill of Rights lists liberties. Grievances against the king are the giveaway. Question 42. Which foundational principle is violated if a government arrests and imprisons a citizen indefinitely without charging them with a specific crime or providing a trial? Option A. Separation of powers. Option B. Due process of law. Option C. Fiscal conservatism. Option D. Republicanism. The correct answer is option B. Due process of law. Indefinite imprisonment without charges or trial violates due process because government is depriving liberty without fair legal procedure. Separation of powers and republicanism are related structural principles, but they do not name the specific protection against arbitrary detention. Due process requires notice, lawful grounds, and an opportunity to be heard. Question 43. What is the definition of a republic? Option A. A government controlled entirely by a hereditary religious elite. Option B. A form of government in which supreme power rests with the citizens and is exercised by elected representatives. Option C. A system where all property is owned collectively by the national state. Option D. A government lacking any formalized written legal codes or permanent courts. The correct answer is option B. A form of government in which supreme power rests with the citizens and is exercised by elected representatives. A republic places supreme political power in the people and uses elected representatives to exercise that power. It is not hereditary religious rule, state ownership of all property, or the absence of legal institutions. The American system is a constitutional federal republic. Question 44. Which amendment protects a citizen's right to own and carry weapons for self-defense? Option A. First Amendment. Option B. Second Amendment. Option C. Third Amendment. Option D. Fourth Amendment. The correct answer is option B. Second Amendment. The Second Amendment protects the right to keep and bear arms, including self-defense as recognized in modern case law. The first protects expression and religion, the third protects against quartering, and the fourth protects against searches. Arms and self-defense point to the Second Amendment. Question 45. Which term refers to the power of the people to vote an elected official out of office before their term expires? Option A, impeachment. Option B, recall. Option C, ouster. Option D, censure. The correct answer is option B, recall. Recall allows voters to remove an elected official before the end of the term. Impeachment is a legislative process, censure is a formal reprimand, and ouster is a broader removal term. The key clue is voters acting before the next regular election. Question 46. According to Federalist No. 51, what is essential to keeping the branches of government separate and preventing an abuse of power? Option A, ensuring that all branches share an identical pool of tax revenue. Option B, giving each branch the necessary constitutional means and personal motives to resist encroachments by the others. Option C, combining the legislative and executive offices into a single governing body. Option D, requiring all federal officials to pass a standard civic virtue exam every 2 years. The correct answer is option B, giving each branch the necessary constitutional means and personal motives to resist encroachments by the others. Federalist No. 51 teaches that each branch needs constitutional means and motives to resist the others. Shared revenue, merged offices, or civic exams would not create effective structural checks. The famous idea is ambition counteracting ambition. Question 47. Which amendment protected individual voting rights by prohibiting discrimination based on sex? Option A, 15th Amendment. Option B, 19th Amendment. Option C, 24th Amendment. Option D, 26th Amendment. The correct answer is option B, 19th Amendment. The 19th Amendment prohibits voting discrimination based on sex. The 15th concerns race, the 24th poll taxes, and the 26th age for voters 18 and older. Sex-based suffrage protection is the 19th. Question 48. What fraction of both houses of Congress must approve a proposed constitutional amendment before it can be sent to the states for ratification? Option A, a simple majority. Option B, 3/5 majority. Option C, 2/3 majority. Option D, 3/4 majority. The correct answer is option C, 2/3 majority. A proposed amendment must receive a 2/3 vote in both houses of Congress before it goes to the states. A simple majority is enough for ordinary legislation, while 3/4 is the state ratification threshold. The amendment process is intentionally difficult. Question 49. In Gitlow v. New York, 1925, the Supreme Court ruled that the First Amendment's protection of free speech applies to state governments, marking the historical beginning of what process? Option A, executive privilege expansion. Option B, selective incorporation. Option C, judicial retention elections. Option D, state nullification. The correct answer is option B, selective incorporation. Gitlow v. New York is an early selective incorporation case applying First Amendment speech protections to the states through the 14th Amendment. It did not rely on federal supremacy or direct Article I power. State application of Bill of Rights freedoms points to incorporation. Question 50. Which constitutional clause requires that the President shall take care that the laws be faithfully executed? Option A, the Take Care Clause. Option B, the Presentment Clause. Option C, the Vesting Clause. Option D, the Commander-in-Chief Clause. The correct answer is option A, the Take Care Clause. The Take Care Clause requires the President to faithfully execute the laws. Presentment concerns bills becoming law, vesting clauses grant broad branch authority, and Commander-in-Chief concerns military command. Execution of laws is the Take Care clue. Question 51. What does the concept of majority rule with minority rights mean in practice? Option A. The political majority can pass any law it wishes, regardless of its impact on minorities. Option B. Decisions are made by majority vote, but the fundamental rights of the minority must always be legally protected. Option C. Minority groups have the power to completely block any majority vote from occurring. Option D. Elections are valid only if a minority candidate wins at least half of the open legislative seats. The correct answer is option B. Decisions are made by majority vote, but the fundamental rights of the minority must always be legally protected. Majority rule with minority rights means elections and votes decide policy, but basic rights remain protected for those who lose. It does not permit unlimited majority power or give minorities a total veto. Constitutional rights keep democracy from becoming simple mob rule. Question 52. What does the 9th Amendment state regarding the rights of the people? Option A. The enumeration of certain rights in the Constitution does not mean other rights do not exist or are denied to the people. Option B, individual citizens must register all personal firearms with the federal government. Option C, citizens cannot be forced to quarter soldiers during times of domestic peace. Option D, all criminal trials must occur within the specific state where the crime took place. The correct answer is option A. The enumeration of certain rights in the Constitution does not mean other rights do not exist or are denied to the people. The Ninth Amendment says listing certain rights in the Constitution does not deny other rights retained by the people. It is not about guns, quartering soldiers, or trial location. The amendment protects the idea that rights are broader than the written list. Question 53. How does the judicial branch check the power of the executive branch? Option A. By refusing to confirm presidential cabinet appointments. Option B. By declaring executive orders or actions unconstitutional through judicial review. Option C. By voting to impeach the president during times of administrative misconduct. Option D. By adjusting the annual operating budget allocated to the White House. The correct answer is option B. By declaring executive orders or actions unconstitutional through judicial review. Courts check the executive by declaring executive actions or orders unconstitutional in actual cases. The Senate confirms appointments, the House impeaches, and Congress controls budgets. Judicial review is the judiciary's core check. Question 54. In DeYoung v. Oregon, 1937, the Supreme Court ruled that the First Amendment's protection of what right applies fully to state governments through the 14th Amendment. Option A, freedom of speech. Option B, freedom of peaceful assembly. Option C, freedom of the press. Option D, the right to petition for redress. The correct answer is option B, freedom of peaceful assembly. DeYoung v. Oregon incorporated the First Amendment right of peaceful assembly against the states. It was not mainly about speech alone, religion, or criminal counsel. Peaceful assembly and state prosecution point to DeYoung. Question 55. What constitutional clause states that federal judicial power extends to all cases arising under the Constitution and federal laws? Option A. The jurisdictional vesting clause of Article 3. Option B. The supremacy clause of Article 6. Option C. The full faith and credit clause of Article 4. Option D. The implied powers clause of Article I. The correct answer is option A. The jurisdictional vesting clause of Article 3. Article III's jurisdictional language extends federal judicial power to cases arising under the Constitution, federal law, and treaties. The Supremacy Clause ranks law, full faith and credit governs interstate recognition, and implied powers concern Congress. Cases arising under federal law are Article 3 jurisdiction. Question 56. What is the constitutional role of the President of the United States regarding foreign policy and relations with other countries? Option A. The President can ratify international treaties without any legislative input. Option B. The President acts as the nation's chief diplomat, negotiating treaties and receiving foreign ambassadors. Option C. The President selects the members of the Senate Foreign Relations Committee. Option D. The President has the sole power to declare war against foreign nations. The correct answer is option B. The President acts as the nation's chief diplomat, negotiating treaties and receiving foreign ambassadors. The President serves as chief diplomat by negotiating treaties, receiving ambassadors, and leading foreign relations. Treaties still require Senate approval, and Congress alone declares war. Foreign policy is shared, but diplomatic leadership belongs to the President. Question 57. What constitutional mechanism prevents a bill from becoming law if the President leaves it unsigned during a time when Congress adjourns within 10 days? Option A, line item veto. Option B, pocket veto. Option C, executive decree. Option D, legislative deferral. The correct answer is option B, pocket veto. A pocket veto occurs when the President does not sign a bill within 10 days and Congress adjourns, preventing its return. A line item veto targets parts of a bill, while executive decree and legislative deferral are not the constitutional mechanism. The clue is unsigned plus congressional adjournment. Question 58. In Everson v. Board of Education, 1947, the Supreme Court incorporated which clause of the First Amendment to the states, while upholding a program reimbursing bus fares for parochial school students? Option A. The Free Exercise Clause. Option B. The Establishment Clause. Option C. The Speech Clause. Option D. The Assembly Clause. The correct answer is option B. The Establishment Clause. Everson incorporated the Establishment Clause against the states while upholding reimbursement for bus transportation to parochial schools. Free exercise protects religious practice, but Everson's major incorporation point is establishment. State aid and church-state separation point to Everson. Question 59. Which piece of legislation passed in 1973 protects threatened and endangered plant and animal species and their critical habitats from commercial destruction? Option A, the National Park Service Act. Option B, the Endangered Species Act. Option C, the Fish and Wildlife Coordination Act. Option D, the Wilderness Preservation Act. The correct answer is option B, the Endangered Species Act. The Endangered Species Act protects threatened and endangered species and their critical habitats. NEPA requires environmental review, the Clean Water Act regulates water pollution, and CERCLA cleans hazardous waste sites. Species protection points to the ESA. Question 60. What type of jurisdiction does the U.S. Supreme Court exercise when it reviews a decision made by a lower federal appeals court or a state Supreme Court? Option A, original jurisdiction. Option B, appellate jurisdiction. Option C, interstate jurisdiction. Option D, summary jurisdiction. The correct answer is option B, appellate jurisdiction. Appellate jurisdiction is the power to review lower court decisions for legal error. Original jurisdiction begins a case, while interstate and summary jurisdiction do not describe Supreme Court review of appeals. Most Supreme Court work is appellate. Question 61. A citizen cannot be forced to testify against themselves in a criminal trial due to protections found in which amendment? Option A, Fourth Amendment. Option B, Fifth Amendment. Option C, Sixth Amendment. Option D, Eighth Amendment. The correct answer is option B, Fifth Amendment. The Fifth Amendment protects against compelled self-incrimination in criminal cases. The Fourth protects against unreasonable searches, the Sixth protects trial rights, and the Eighth limits punishments. The phrase pleading the Fifth comes from this protection. Question 62. In New York Times Company v. United States, 1971, often called the Pentagon Papers case, the Supreme Court ruled against the government's use of what action? Option A, subpoena power over investigative journalists. Option B, prior restraint, censorship before publication, of news materials. Option C, electronic surveillance of foreign embassy communications. Option D, levying punitive corporate taxes on media companies. The correct answer is option B, prior restraint, censorship before publication, of news materials. New York Times Company v. United States rejected prior restraint in the Pentagon Papers dispute, protecting publication absent an extraordinary justification. It was not about taxes, embassy surveillance, or subpoenas over sources. Censorship before publication is prior restraint. Question 63. What major legislation passed in 1947 regulated the activities and power of labor unions, restricting wildcat strikes and banning closed shops? Option A, the Wagner Act. Option B, the Taft-Hartley Act. Option C, the Landrum-Griffin Act. Option D, the Fair Labor Act. The correct answer is option B, the Taft-Hartley Act. The Taft-Hartley Act limited certain union practices and amended federal labor law after the New Deal era. The Fair Labor Standards Act covers wage and hour rules, while OSHA covers workplace safety. Union power and labor management regulation point to Taft-Hartley. Question 64. What was the legal outcome of the infamous Dred Scott v. Sandford, 1857, Supreme Court decision? Option A. It declared that African Americans, whether enslaved or free, were not citizens and that Congress could not ban slavery in U.S. territories. Option B. It established this separate but equal doctrine for public transportation systems. Option C. It ruled that state-level segregation laws were a direct violation of the Privileges Clause. Option D. It forced northern states to pay financial restitution for runaway slaves. The correct answer is option A. It declared that African Americans, whether enslaved or free, were not citizens and that Congress could not ban slavery in U.S. territories. Dred Scott v. Sandford held that African Americans were not citizens and that Congress lacked power to ban slavery in the territories. Plessy created separate but equal, and later civil rights cases rejected segregation. The decision is infamous because it protected slavery and denied citizenship. Question 65. Which landmark piece of civil rights legislation passed in 1990 explicitly banned discrimination against individuals with disabilities in employment, transportation, and public communications? Option A. The Rehabilitation Act. Option B. The Americans with Disabilities Act. Option C. The Individuals with Disabilities Education Act. Option D. The Equal Opportunity Act. The correct answer is option B. The Americans with Disabilities Act. The Americans with Disabilities Act broadly prohibits discrimination against individuals with disabilities and requires accessibility in employment, public services, and public accommodations. The Civil Rights Act of 1964 covers other protected classes, and Title IX focuses on education sex discrimination. Disability discrimination points to the ADA. Question 66. Which amendment contains the citizenship clause that grants birthright citizenship to anyone born or naturalized in the United States? Option A, 12th Amendment. Option B, 13th Amendment. Option C, 14th Amendment. Option D, 15th Amendment. The correct answer is option C, 14th Amendment. The 14th Amendment contains the citizenship clause, granting citizenship to people born or naturalized in the United States and subject to its jurisdiction. The 13th abolished slavery, and the 15th protected voting regardless of race. Birthright citizenship points to the 14th. Question 67. The mechanism of a presidential veto over legislation passed by Congress is an example of what constitutional dynamic? Option A, a state check on federal legislative powers. Option B, an executive check on the legislative branch. Option C, a judicial check on the executive branch. Option D, a legislative check on the judicial branch. The correct answer is option B, an executive check on the legislative branch. A presidential veto is an executive check on Congress because it lets the president reject legislation passed by the legislative branch. It is not a state check or a judicial check. Congress can still respond through the constitutional override process. Question 68. What is the fundamental purpose of the justice system within a society governed by the rule of law? Option A, to enforce the political agenda of the ruling party without exception. Option B, to provide fair, predictable, and impartial resolution of legal disputes based on established laws. Option C, to maximize the financial revenue generated through public fines and asset forfeitures. Option D, to ensure that the legislature cannot amend the Constitution without judicial approval. The correct answer is option B, to provide fair, predictable, and impartial resolution of legal disputes based on established laws. A rule of law justice system resolves disputes through fair procedures, established legal standards, and impartial decision-makers. It is not designed to enforce a party agenda, raise revenue, or give courts control over constitutional amendment rules. The point is predictable justice rather than arbitrary power. Question 69. In Weeks v. United States, 1914, the Supreme Court established the exclusionary rule for what level of government? Option A, state municipal police forces only. Option B, the federal government and federal law enforcement agencies. Option C, tribal reservation courts. Option D, military tribunals operating overseas. The correct answer is option B, the federal government and federal law enforcement agencies. Weeks v. United States created the exclusionary rule for federal law enforcement. Mapp later applied that rule to the states. The distinction to remember is Weeks for federal officers and Mapp for state prosecutions. Question 70. How often does the Constitution require the federal government to conduct an official population census to reportion the House of Representatives? Option A, every 4 years. Option B, every 5 years. Option C, every 10 years. Option D, every 20 years. The correct answer is option C, every 10 years. The Constitution requires a census every 10 years to apportion seats in the House. 4- and 5-year intervals are too short, and 20 years would not update representation often enough. The decennial census is the representation count. Question 71. The 19th Amendment, ratified in 1920, expanded the electorate by granting the right to vote to which group? Option A, naturalized citizens. Option B, Native Americans. Option C, women. Option D, residents of Washington, D.C. The correct answer is option C, women. The 19th Amendment prohibited denying the vote on the basis of sex, expanding suffrage to women nationwide. It did not specifically address naturalized citizens, Native Americans, or D.C. presidential electors. The date 1920 is the major memory cue. Question 72. What type of democracy exists when citizens elect individuals to make public policy decisions on their behalf? Option A, direct democracy. Option B, representative democracy, republic. Option C, participatory democracy. Option D, autocratic democracy. The correct answer is option B, representative democracy, republic. Representative democracy, or a republic, uses elected officials to make policy on behalf of citizens. Direct democracy has citizens vote on laws themselves, and autocracy gives power to a ruler rather than the people. The key clue is electing decision-makers. Question 73. Which document first established the principle that the monarch's power was not absolute and guaranteed basic due process rights to English barons in 1215? Option A, the English Bill of Rights. Option B, the Mayflower Compact. Option C, the Magna Carta. Option D, the Petition of Right. The correct answer is option C, the Magna Carta. The Magna Carta limited the English king in 1215 and helped establish due process as a restraint on arbitrary royal power. The English Bill of Rights came centuries later. The Mayflower Compact was a colonial self-government agreement, and the Petition of Right addressed later conflicts with the monarchy. The key clue is 1215, which points directly to Magna Carta. Question 74. Which amendment granted citizens residing in Washington, D.C., the right to vote for presidential electors in the Electoral College? Option A, 21st Amendment. Option B, 23rd Amendment. Option C, 24th Amendment. Option D, 25th Amendment. The correct answer is option B, 23rd Amendment. The 23rd Amendment gives residents of Washington, D.C., participation in presidential elections through electoral votes. The 24th concerns poll taxes, and the 25th concerns succession and disability. D.C. presidential electors are the memory queue. Question 75. In Klopfer v. North Carolina, 1967, the Supreme Court incorporated which Sixth Amendment protection to state criminal proceedings? Option A, the right to a public trial. Option B, the right to a speedy trial. Option C, the right to confront witnesses. Option D, the right to compulsory process. The correct answer is option B, the right to a speedy trial. Klopfer v. North Carolina incorporated the Sixth Amendment right to a speedy trial against the states. Gideon concerns counsel, Duncan concerns jury trial, and Miranda concerns interrogation warnings. Speedy trial and state prosecution point to Klopfer. Question 76. What was the purpose of the Annapolis Convention of 1786? Option A, to sign the official peace treaty ending the Revolutionary War. Option B, to discuss the commercial barriers and economic defects under the Articles of Confederation. Option C, to elect the first national Chief Justice of the United States. Option D, to coordinate the defense of coastal cities against privateers. The correct answer is option B, to discuss the commercial barriers and economic defects under the Articles of Confederation. The Annapolis Convention met to address trade barriers and economic problems under the Articles of Confederation. It did not end the Revolutionary War or elect the first Chief Justice. Its limited turnout helped lead to the Philadelphia Convention. Question 77. The dynamic where state governments act as laboratories of democracy by testing innovative policies describes an advantage of which system? Option A, unitary system. Option B, federalism. Option C, parliamentary system. Option D, direct monarchy. The correct answer is option B, federalism. Federalism lets states experiment with policies, creating laboratories of democracy. A unitary system centralizes policy, while parliamentary government and monarchy concern different institutional structures. State-level experimentation is an advantage of divided state-national power. Question 78. Which principle prevents the federal government from establishing an official national religion that all citizens must follow? Option A, the Free Exercise Clause. Option B, the Establishment Clause. Option C, the Supremacy Clause. Option D, the Full Faith and Credit Clause. The correct answer is option B, the Establishment Clause. The Establishment Clause bars government from creating or endorsing an official national religion. The Free Exercise Clause protects religious practice, while the Supremacy and Full Faith and Credit Clauses address federal law and state records. Establishment is the key term for government-sponsored religion. Question 79. Which document was written by the Pilgrims in 1620 to establish a self-governing colony based on the consent of the community members? Option A, the Fundamental Orders of Connecticut. Option B, the Albany Plan of Union. Option C, the Mayflower Compact. Option D, the Virginia Declaration of Rights. The correct answer is option C, the Mayflower Compact. The Mayflower Compact was a 1620 agreement by Pilgrims to form a self-governing political community. The Fundamental Orders, Albany Plan, and Virginia Declaration came from different times and purposes. The key clues are Pilgrims, 1620, and consent of community members. Question 80. In Meyer v. Nebraska, 1923, the Supreme Court struck down a state law banning the teaching of foreign languages to children, protecting what right? Option A, the commercial freedom of private school corporations. Option B, the liberty of parents to direct the education of their children under the Due Process Clause. Option C, the right of states to determine local educational metrics. Option D, the freedom of speech rights of international exchange students. The correct answer is option B, the liberty of parents to direct the education of their children under the Due Process Clause. Meyer v. Nebraska protected parental and educational liberty under the Due Process Clause by striking down a ban on teaching foreign languages. It was not primarily a free speech or equal protection ruling. Parents directing a child's education is the Meyer Q. Question 81. What major compromise at the 1787 Constitutional Convention resolved the dispute over legislative representation by creating a bicameral Congress with one house based on population and the other based on equal representation? Option A, the Three-Fifths Compromise. Option B, the Commerce Compromise. Option C, the Great Connecticut Compromise. Option D, the Electoral College Compromise. The correct answer is option C, the Great Connecticut Compromise. The Great, or Connecticut, Compromise created a bicameral Congress with proportional representation in the House and equal state representation in the Senate. The Three-Fifths Compromise addressed enslaved persons for representation and taxation, not the two-house structure. Representation disputes point to the Great Compromise. Question 82. Under the U.S. Constitution, what body has the explicit power to try all cases of impeachment involving federal officials? Option A, the U.S. House of Representatives. Option B, the U.S. Senate. Option C, the U.S. Supreme Court. Option D, the Department of Justice. The correct answer is option B, the U.S. Senate. The Senate tries impeachments and decides whether to convict and remove federal officials. The House brings impeachment charges, while courts and the Justice Department do not conduct impeachment trials. Impeachment is split between the two chambers. Question 83. Which system of checks and balances allows the legislative branch to counter an abusive or criminal executive leader? Option A, judicial review. Option B, the power of impeachment and removal. Option C, the pocket veto. Option D, declaratory judgments. The correct answer is option B, the power of impeachment and removal. Impeachment by the House and possible removal by the Senate allow Congress to respond to serious executive misconduct. Judicial review belongs to courts, and vetoes belong to the president. This is the legislative branch's strongest constitutional check on an abusive executive. Question 84. What did the Supreme Court decide regarding federal campaign finance laws in the landmark case Citizens United v. Federal Election Commission, 2010? Option A, corporations and unions have a First Amendment right to spend unlimited independent amounts of money on political communications. Option B, political action committees are completely banned from donating money to congressional candidates. Option C, foreign corporations are granted identical political spending rights as domestic citizens. Option D, all political advertisements must be funded exclusively by the federal government. The correct answer is option A. Corporations and unions have a First Amendment right to spend unlimited independent amounts of money on political communications. Citizens United held that corporations and unions may spend unlimited independent funds on political communications under the First Amendment. It did not ban political action committees or give foreign corporations the same campaign rights. The key word is independent expenditures. Question 85. Which permanent committee in the Senate reviews all potential judicial appointments before they are voted on by the full chamber? Option A, the Foreign Relations Committee. Option B, the Finance Committee. Option C, the Judiciary Committee. Option D, the Armed Services Committee. The correct answer is option C, the Judiciary Committee. The Senate Judiciary Committee reviews federal judicial nominees before the full Senate votes. Foreign Relations handles diplomacy, Finance handles taxes and spending programs, and Armed Services handles military matters. Judicial appointments point to judiciary. Question 86. Which landmark case addressed the issue of legislative redistricting, ruling that urban districts must be apportioned equally under the principle of one person, one vote? Option A, Baker v. Akar, 1962. Option B, Jerry v. United States, 1954. Option C, Shaw v. Reno, 1993. Option D, Marbury v. Madison, 1803. The correct answer is option A, Baker v. Akar, 1962. Baker v. Carr opened the door for federal courts to hear legislative apportionment challenges, supporting later one person, one vote doctrine. It was not a gerrymandering case called Jerry or a judicial review case like Marbury. Redistricting and equal representation point to Baker in this question set. Question 87. Which amendment prohibits Congress from voting itself a pay raise that takes effect before the next intervention of an election of representatives? Option A, 25th Amendment. Option B, 26th Amendment. Option C, 22nd Amendment. Option D, 27th Amendment. The correct answer is option D, 27th Amendment. The 27th Amendment delays congressional pay raises until after an intervening House election. The 25th handles succession, the 26th voting age, and the 22nd presidential terms. Congressional pay timing points to the 27th. Question 88. What type of power is the federal government's ability to acquire new geographic territories, which is not explicitly stated but stems from national sovereignty? Option A, enumerated power. Option B, reserved power. Option C, inherent power. Option D, concurrent power. The correct answer is option C, inherent power. Acquiring territory is an inherent power tied to national sovereignty, even though it is not expressly listed in the Constitution. Enumerated powers are written, reserved powers belong to states, and concurrent powers are shared. The Louisiana Purchase is the classic example of this idea. Question 89. Under Article 2 of the Constitution, what is a primary constitutional qualification required to serve as President of the United States? Option A, must be a college graduate from an accredited institution. Option B, must be a natural-born citizen of the United States. Option C, must have served at least 4 years in the U.S. military. Option D, must have prior experience as a state governor or senator. The correct answer is option B, must be a natural-born citizen of the United States. Article 2 requires the President to be a natural-born citizen, at least 35 years old, and a U.S. resident for 14 years. A college degree, military service, or prior state office may be politically useful but is not constitutionally required. The Constitution lists only a few formal qualifications. Question 90. How can the legislative branch check the power of the judicial branch under the U.S. Constitution? Option A, by altering the size of the Supreme Court and confirming or rejecting judicial nominees. Option B, by issuing an executive order that pardons individuals convicted by federal courts. Option C, by removing a judge from the bench through a unilateral decree from the Speaker of the House. Option D, by rewriting a court ruling to reverse a judicial decision directly. The correct answer is option A, by altering the size of the Supreme Court and confirming or rejecting judicial nominees. Congress can check the judiciary by setting the size and structure of lower federal courts, confirming or rejecting nominees, and using impeachment for misconduct. Pardons are executive, and Congress cannot simply rewrite a court ruling as if it were a judgment. Legislative checks operate through appointments, structure, jurisdiction, and removal. Question 91. Which landmark pieces of legislation passed in 1965 established the federal regulatory framework for matching grant assistance to low-income and elderly healthcare systems? Option A, the Public Health Service Act. Option B, the Social Security Amendments of 1965, Medicare and Medicaid. Option C, the Federal Insurance Contributions Act. Option D, the Health Equity Act. The correct answer is option B, the Social Security Amendments of 1965, Medicare and Medicaid. The Social Security Amendments of 1965 created Medicare and Medicaid, the federal health insurance programs for elderly and low-income Americans. The original Social Security Act created retirement and unemployment programs but not those health systems. Medicare plus Medicaid points to the 1965 amendments. Question 92. Which system of economy is most closely aligned with the American democratic emphasis on individual liberty and limited government intervention? Option A, command economy. Option B, traditional barter economy. Option C, market economy, capitalism. Option D, state-directed mercantilism. The correct answer is option C, market economy, capitalism. A market economy uses private choice, competition, and limited government direction, matching the American emphasis on economic liberty. A command economy places production under state control, and traditional barter lacks modern market institutions. Capitalism is the economic system most associated with private property and voluntary exchange. Question 93. Which position holds the highest institutional authority and power within the United States House of Representatives? Option A, the Majority Leader. Option B, the Speaker of the House. Option C, the Dean of the House. Option D, the Chairman of the Ways and Means Committee. The correct answer is option B, the Speaker of the House. The Speaker of the House holds the highest institutional authority in the House, presiding over the chamber and controlling much of its agenda. Majority leaders and committee chairs are powerful but subordinate to the Speaker's institutional role. The Speaker is also high in presidential succession. Question 94. What piece of legislation passed in 2010 expanded health insurance coverage across the nation through individual mandates and health insurance marketplaces? Option A, the Medicare Modernization Act. Option B, the Patient Protection and Affordable Care Act, Obamacare. Option C, the Health Care Financing Act. Option D, the Children's Health Insurance Act. The correct answer is option B, the Patient Protection and Affordable Care Act, Obamacare. The Affordable Care Act expanded health insurance coverage through exchanges, subsidies, Medicaid expansion mechanisms, and insurance reforms. It is not Medicare's original creation or the 1935 Social Security system. Modern health coverage expansion points to the ACA. Question 95. Which federal agency is an example of an independent regulatory commission that operates outside the direct control of the executive departments? Option A, the Department of Defense. Option B, the Federal Communications Commission, FCC. Option C, the National Park Service. Option D, the Bureau of Indian Affairs. The correct answer is option B, the Federal Communications Commission, FCC. The Federal Communications Commission is an independent regulatory commission, not a cabinet department. The Defense Department, National Park Service, and Bureau of Indian Affairs sit within the executive department structure. Independent commissions regulate specialized sectors with some insulation from direct presidential control. Question 96. Which action represents a legal obligation of a United States citizen rather than a purely voluntary civic action? Option A, organizing a neighborhood petition drive. Option B, attending a city council meeting. Option C, participating in federal jury duty when called. Option D, donating to a political action committee. The correct answer is option C, participating in federal jury duty when called. Federal jury duty is a legal obligation when a citizen is summoned. Petitioning, attending meetings, and donating to political groups are voluntary forms of civic participation. The key distinction is whether the law can require the action. Question 97. What constitutional right did the Supreme Court recognize and establish for indigent criminal defendants in the landmark case Gideon v. Wainwright, 1963? Option A, the right to remain silent during police interrogations. Option B, the right to a state-appointed defense attorney if they cannot afford one. Option C, the right to avoid being tried twice for the same criminal action. Option D, the right to a trial entirely free from any public media coverage. The correct answer is option B, the right to a state-appointed defense attorney if they cannot afford one. Gideon v. Wainwright required states to provide counsel for indigent defendants in serious criminal cases. Miranda concerns warnings during interrogation, and double jeopardy is a separate Fifth Amendment protection. The right to appointed counsel is Gideon. Question 98. How are positions within the federal judiciary filled under the rules of the United States Constitution? Option A, appointed by the President and confirmed by a majority vote in the Senate. Option B, elected directly by the public in nationwide judicial primary elections. Option C, selected by a council of state Supreme Court justices based on senior status. Option D, chosen by a lottery system from among practicing constitutional attorneys. The correct answer is option A, appointed by the President and confirmed by a majority vote in the Senate. Federal judges are nominated by the President and confirmed by the Senate. They are not elected nationally, chosen by state judges, or selected by lottery. This appointment process is another example of checks and balances. Question 99. Which clause of the First Amendment prevents the government from interfering with a citizen's right to practice their chosen religion? Option A, the Establishment Clause. Option B, the Free Exercise Clause. Option C, the Privileges and Immunities Clause. Option D, the Presentment Clause. The correct answer is option B, the Free Exercise Clause. The Free Exercise Clause protects religious belief and practice from unjustified government interference. The Establishment Clause bars government sponsorship of religion, while the Privileges and Immunities and Presentment Clauses address different topics. Practice of religion points to free exercise. Question 100. Which document served as the first written Constitution of the United States but was eventually replaced due to its creation of a weak central government? Option A, the Declaration of Independence. Option B, the Articles of Confederation. Option C, the Federalist Papers. Option D, the Northwest Ordinance. The correct answer is option B, the Articles of Confederation. The Articles of Confederation were the first written national constitution of the United States and created a weak central government. The Declaration announced independence, the Federalist Papers defended the later Constitution, and the Northwest Ordinance governed Western Territory. Weak national authority is the Article's clue.